Good afternoon. It's 2 o'clock Brussels time, wherever you are. This is the webinar, the fifth webinar on the independence of the judiciary and the access to justice in Turkey nowadays. It's a full-loaded webinar because we have very high-level guests, a good report. I welcome everyone who is here. And we will immediately start. For the people who are listening in English, of course, most people will talk in English, but we have a translation English and Turkish. So if you want to listen in Turkish, you can do that. If someone is speaking in Turkish, you can have the translation in English. For that, you have to push up the button in your screen on interpretation, and that will work. I would like to thank all the people who are helping to organize this webinar. And we will not lose a lot of time with introduction. And I would like to give the floor to Mr. Luca Perilli. He is the judge who has been writing our report, a quite substantial report. Thank you very much, Luca, for taking this effort. And I give you the floor for around 15 minutes to clarify the report. People who are not speaking, can I ask to mute? I will do it myself also, so we have no double sound. Luca, it's yours.
So thank you very much, Professor Lanotte. Good afternoon to everyone. Why I was proposed to draft this report? Because I was EU independent expert in Turkey since 2008 up to 2015 in several missions in the context of Chapter 23 of the negotiation for the accession of Turkey to the European Union, which is judiciary and fundamental rights. And during those years, I had the opportunity to meet many stakeholders at the institutional level, also at the level of the civil society. I've been to Turkey many times, also in the southeast part of Turkey. And I also had access to information that are normally not available to the general public, even though most of times my report had been published by the Turkish government in the Ministry of Justice website. And I'm saying this because, as you will see in my report, I've tried to ground my statements on the basis of accredited sources of information, and I try to read the judicial system in Turkey in the light of international standards about rule of law. And this makes this report a long one, and it's very difficult to sum up it in few minutes, the time that has been given to me today. But it's important to highlight that in the report, it is an image of the judicial history of Turkey in the last 10 years. Because if we look only at the time of Turkey after July 16, when the so-called coup d'etat happened in Turkey in the last 5 years, we see a country in which more than 300 journalists, thousands of judges, prosecutors, and lawyers, also the president of the Free Association of Judges, Yarsav, or the president of an association of lawyers, the Progressive Lawyers, or free minds, academicians, writers were detained. It would be easy to conclude that there is no rule of law in Turkey. But we have to be more analytical to try to consider what happened in Turkey along the years and why we have come to this point, which is not only the consequence of the coup d'etat, but the situation of the coup d'etat is rooted, the reaction of the government to the coup d'etat is rooted much before. So in my report, I identify a turning point in year 2013. I was discussing with Filipe and said, we saw signs even before in 2012. There were many troubles in Turkey along the year, but it's important to remark that since when I started to work in Turkey, 2008, positive reforms had been adopted along the paths to the accession to the European Union. And an important date for me is 2010, because in 2010, constitutional reforms were passed and then confirmed by a referendum in September 2010. And these reforms made two very important changes. The first one was a new mechanism in front of the Constitutional Court, the individual application for the protection of fundamental rights, similar to the mechanism existing for the Court of Human Rights or in front of the Spanish and the German Constitutional Court. And the second one was the change of the composition of the Judicial Council, which passed from 7 to 22 members. But what is more important, the system of elections, the sense that the majority of the members of the council were elected by the peers, 16 out of 22, and even by the lower instances. So finally, Turkey had an independent Judicial Council, and this produced effects in the judiciary in the sense that judges and prosecutors started to act really independently. That means that they started to protect the rights of the citizens and not only the interests of the state, because before that, the judicial system was highly hierarchical. For what regards the Constitutional Court, let me just mention very few examples that clearly describe the situation before and after 2016. For example, the Balbay ruling adopted in the context of the individual application. Mustafa Balbay was an important journalist in Turkey who has been detained in relation to high-profile cases investigated in that time in Turkey, Ergenekon and Oda TV case. And he was detained for more than 2 years. And upon an application to the court, he was released by the Constitutional Court, because in the meantime, he had been elected as member of the parliament. After 2016, the immunity of many members of the parliament was lifted, and these members of the parliament were detained on allegation of terrorism. And many of them are still in jail. The most important case is Selahattin Demirtas, the co-chair of the HDP, which is also a famous case of the Court of Human Rights. The Grand Chamber adopted the final decision in December 2020. The second one is the case of Can Dündar, who is an important journalist again, who made an article in May 2015 about a truck that was allegedly bringing weapons to the Syrian rebels. This truck was seized by the prosecutors and by the police, and the journalist published an article on this case, and he was arrested because of this article, and then he was made free by the Constitutional Court after 92 days in detention. In 2020, after the coup d'etat, in absentia, Can Dündar was convicted to 18 years and 9 months in jail. What I want to say that still in 2013, 14, and 15, even though the climate had changed, there was still a rule of law, because the decision of an independent court were enforced in Turkey, even though they were slammed, for example, by the president, that in a famous case, the Twitter ban case, said that he did not respect the decision of the Constitutional Court, that nevertheless was implemented. And but the real change happened not in 2016, but in 2013. Why? A very important sign was in May 2013, the famous Ghazi Park protest that everyone remembers, I think, because they were covered by television for 20 days. 2.5 million people involved in protest to protect what? Fundamental liberties of the society, the freedom of press, the freedom of expression, the freedom of assembly. And it was peaceful protests that were repressed by the police violently. And there are many reports about that. And this unveiled the authoritarian phase of the government that was intolerant to the civil liberties at that time. But the turning point, according to my evaluation, was in December 2013, when an independent judiciary, because an independent council, started to investigate in the businesses of the government. And 3 sons of the members of the cabinet and other 34 people connected with the government were arrested. At that point, the reaction of the government was institutionally violent, in the sense that a law was adopted against the council, which had defended the prosecutors, in order to deprive the council of its independent powers. So the third chamber of the council was taken under control of the government. The chamber was in charge with the transfer and appointment of judges. And at that point, a mass transfer of judges started, and it was 2014. In 2015, not only transfer, but also arrest of judges who were performing their professional activity. So the climate that we see in July 2016 started much before. And this also explained to a certain extent what the president said after the coup d'etat, when he affirmed that the coup d'etat was a gift from God. And if we look at the deliberation of the Parliamentary Assembly of the Council of Europe of 25 April 2017, the Assembly said that the state of emergency has been used not only to remove those involved in the coup from the state institution, but also to silence any critical voices. And what happened after July 2016 is well known. I will not remember the enormous figures of what happened in Turkey in the past years. Let me just mention few figures regarding the judiciary. On 16 July, the day after, layoff of 2,745 judges and prosecutors, a proscription list prepared in advance because it was the following day of the coup d'etat. And 5 members of the High Judicial Council fired. Arrest warrants for 140 members of the Supreme Court of Appeal. There were only 2 levels of jurisdiction at that time. 40 members of Danistai, Council of State, hit by arrest warrants. And 2 judges of the Constitutional Court, Alparslan Altan and Erdal Terkan, that Constitutional Court that in the previous year defended the fundamental rights of the citizens, were the 2 first judges to be arrested. And again, Alparslan Altan is an important landmark case of the Court of Human Rights, and is still in jail. And the Association of Judges dissolved. After that, detention of thousands of judges and prosecutors, mass transfer of judges and prosecutors, ill treatment of judges and prosecutors. Some died in prisons, unfortunately. And the change again of the Constitution in 2017, thanks to constitutional amendment confirmed in a very controversial referendum, which brought the council under the control, the final and institutional control of the government. Therefore, in my report, when you will look at the concept of systemic deficiencies, which is used by the Court of Justice of European Union in order to identify a violation of rule of law, I try to explain that these systemic deficiencies relate to all the aspects of independence: external independence, internal independence, individual independence, the principle of natural judge, the free right of association, the appearance of impartiality, the independence of the Judicial Council. And without an independent judiciary, it's impossible to have a proper access to justice and effective decision, because the independence is not for the sake of judges and prosecutors, but it's for the protection of the fundamental rights of the citizens. But in my report, I have identified, and I'm going to the closure short, many aspects, critical aspects of violation of access to justice. Obstacle for the defense, suspension of the liar-client privilege, lack of evidence in supporting detention and convictions, disruption of the right to a fair public trial, abuse of pretrial detention, using itself of a summary punishment, and the non-enforcement of decisions adopted by the court, differently from the past. The decision to release detainees not enforced. The first decision of the Court of Human Rights in famous cases, I've already mentioned some, Alparslan Altan, Akan Bash, Salatin Demirtas, Osman Kavala, they have not been enforced by the Turkish institution. And the last point, let me mention the last point, was not enough, because the final action targeted the human rights defenders, who are the last shelter for the protection of fundamental rights. The persecution of lawyers, hundreds of lawyers arrested and detained, and we have already in our eyes the face on Ebru Timkit, who died after more than 200 days in hunger strike in the Silveri prison, but also the NGOs were targeted by the government. More than 1,400 associations were closed because of the emergency decrees, active in the field of the protection of human rights. Important international NGOs were targeted by the arrest and the detention. We can only mention the case of the director and the chief of Amnesty International. And the same happened to journalists, writers. I would like only to mention a case which has not been decided by the Court of Human Rights, which is the case of Ahmet Altan. So I closed my report with some words that also close my speech of today. That is, without effective judicial protection of fundamental rights, there is no justice, and without justice, there is no rule of law. Thank you.
Thank you very much, Luca. That was very concise and clear, I think. The second speaker is Mr. Diego García-Sayán, who, between other things, has been president of the Inter-American system, the Inter-American judge at the Inter-American system, and was president there. And he's now a special rapporteur on the independence of judges and lawyers for the Office of the High Commissioner of the United Nations. And of course, independence of judges and lawyers, not only in Turkey, but also other places, are important elements. And we're very pleased that we have Mr. Diego García-Sayán with us. And I'm glad you can give us some insight in your work you're doing on and how you evaluate the situation. Thank you very much.
Thank you very much, Mr. Vande, Lanotte, dear friends and colleagues. I am really thankful for the invitation to be here with you today and to have the opportunity to meet this highly qualified group monitoring and pushing forward for rule of law and independence of justice in Turkey. Congratulations, Luca Perilli, for your fantastic report and for your presentation now, which gives a whole idea of a process that has many years and that didn't begin in 2016. There are a lot of important elements that can be of some use in other countries in which similar steps can be taken, and at the end of the day, one can wonder how this may finish if this process continues in the same view. As you are perfectly aware, the independence of the judiciary and consistent respect for the legal profession are fundamental pillars of a democratic society. There are, as well, essential part of very well-known international standards, like the basic principles of independence of judges, the basic principles of the function of lawyers, and so on. Such independence is not provided for the benefit or protection of judges or lawyers as such, as you well know, nor is it intended to shield them from being held accountable in the performance of their professional duties and to general law. Instead, its purpose is the protection of the people, affording them an independent and effective judiciary and legal profession as bulwarks of a free and democratic society. But we are aware of this, so the opponents of rule of law, promoters of authoritarianism and of justice at the service of particular interests, of impunity, corruption, and human rights violations. While in some countries and regions of the world, transitions to democracy have contributed to a significant improvement in the conditions for an independent justice and for the free exercise of the legal profession, in other countries, democratic rights are in regression, and judges and members of the legal profession are under attack. For its consistent pattern, extension in time, and number of judges and lawyers affected, this seems to be what is happening in Turkey since 2016, besides, of course, the elements of background that has been mentioned today by Luca Perilli. Since 2016, turning to be an iconic example of a pattern of demolition of judicial independence and rule of law. Your report on what is happening on Turkey, judicial independence and access to justice is a very important contribution for the analysis and description of what is happening in that beautiful and fantastic country that doesn't deserve hundreds of judges and lawyers harassed, persecuted, imprisoned, or killed. Congratulations, Luca Perilli and the team that have prepared with you this report. As in other country that pretext of a war against drugs is being used to persecute and kill judges and lawyers, it is in the name of the so-called war against terror that judicial independence is being questioned and attacked in Turkey. A combination of anti-terror legislation with some vague definitions in the Turkish criminal code and biased interpretation made by some Turkish judges and prosecutors allows the criminalization of harmless acts and even the exercise of fundamental rights, as it is mentioned in your report. You mentioned in your report, and you have mentioned it again now, Professor Perilli, the case of Ebru Timcik, rearrested in September 2017. She died, as was mentioned, on August last year in prison after 238 days into a hunger strike demanding a fair trial. Her tragic death has been a dramatic denounce of the demolition of rule of law and of fair trial affecting dozens of lawyers. Aytaç Unsal, other lawyer that was as well in hunger strike with Ebru Timcik, finally was released in September last year following a decision of the Supreme Court. I have had the opportunity to meet him in November last year through a video conference organized by the Council of Bars and Law Societies of Europe. I was, of course, very glad to see him safe and alive. Whenever rule of law is demolished, usually not only the individual function of lawyers suffers, but their bar associations are attacked with ferocity. In Turkey, more than 30 bar associations have been seized and their directors arrested, as I reported to the General Assembly of the United Nations in 2018. You mentioned in your report as well the case of the president of the Diyarbakir Bar Association, Mehmet Emin Akhtar, which in January this year was sentenced to 6 years and 3 months in prison under Article 314 of Penal Code. International organizations, multilateral and non-governmental, can play in this dramatic situation very important and proactive roles and eventually achieve some specific results that perhaps won't change dramatically in the short run the general figure, but improves or saves the lives of some judges or lawyers. The international community has here a role to play. From the UN, I will continue to insist in an official visit to Turkey, as I have been doing for the last years. I have been told that some things that I am saying are not based in facts. Well, I would like to verify that and have a discussion in the field with the authorities and, of course, with representatives of lawyers and judges. But Turkey is member not only of the United Nations and of the Council of Europe, but a state party of the European Court of Human Rights, as it is recalled in the report. It's amazing that in the few cases on Turkey ruled by the European Court, among the hundreds that had not been yet admitted in the name of non-exhaustion of internal remedies, as it is publicly known, Turkish courts are openly refusing to comply with a regional court ruling. This doesn't seem consistent with international law, and I am sure that some steps can be taken in that regard. I have been judge and president of the Inter-American Court of Human Rights for some years. One of the key phases of a judicial process in an internal or international tribunal is, of course, the compliance or non-compliance of the rulings of a court. In the case of the Americas, the treaty establishes that it's the court itself which is in charge of monitoring the compliance of the rulings, and it works. In the case of Europe, that function is not of the European Court, but of the political body. The Committee of Ministers is in charge of the supervision of the execution of the rulings of the European Court. I am sure that with the participation of organizations like the one that has prepared this report, the European Association of Judges headed here by my friend José Igreja, may have eventually some comments regarding what steps can be taken so that the Committee of Ministers really enters to this matter substantially. Really, I don't want to take you much more time. I want to congratulate again for this report that gives a broad idea of a process that can take place in other parts of the world, in which that incremental steps that reduce oxygen for democratic institutions, for justice, for the role of lawyers, for the function of lawyers, can gradually lift society without a minimum doses of oxygen to survive democratically. So it's important to present this report. And I really want to congratulate you and thank you again for inviting me to be here with you today. I wish to take this opportunity to share my hope that ways can be opened for the affirmation of the rule of law in Turkey, avenues of respect for independence of the judiciary and the role of lawyers. Thank you very much and congratulations again.
Thank you very much, Diego. We have some questions that we will try in a concise way to answer. First question was to Diego. The question that was asked is, will you as UN Special Rapporteur, will you be allowed to undertake your visits and to have access to what you want? What is your estimation of that? Someone asked that.
Well, as I mentioned in my report, but I should be more explicit, and not in the case of Turkey, but in any country, and a special rapporteur of the UN needs an official invitation to pay an official visit. So that's a requirement being placed not by Turkey, but in any case that is a procedure that I must follow, and it's a rule that is very easy to understand, because an official visit means that you will have opportunity to discuss openly with different authorities, and especially better with high levels authorities. So eventually, in some cases, these reports, these visits can be openly made by the governments, which in some cases they see that the special rapporteur can be of some use, whose ideas, whose questions may help internal institutions to improve the situation of judiciary and rule of law. In other cases, it obeys to a context of questioning by international community and observers. But in any case, the function of a visit is not to punish the country which is inviting the rapporteur, but to open a dialogue that doesn't exclude, of course, questions that not necessarily are always comfortable, and a final report in which the role of a rapporteur is to make proactive contributions so that the situation can improve. All countries which are members of the UN are parts of basic standards that all countries should follow. So I will continue to expect positively and optimistically that the visit can be made, and nobody will be punished after that, but only the truth that can be used so to improve a situation that is openly being a matter of concern for many institutions in the world.
Thank you. There is a question also for Luca about, someone is asking, we know the high-profile cases of Ergenekon, Balios, ECK. What was the role of the dismissed judges and prosecutors, or some of them, in this high-profile cases? I think you gave some explanation, but if someone said, what was the role exactly of the people who were dismissed in this Ergenekon, Balios cases? You're on mute, Luca.
Yes, I'm coming. So if I get properly this question, so these cases were tried by special courts. I drafted a report about the so-called anti-terror courts that were changed many times along the year. They were also a subject for a decision of the Court of Human Rights in the past. And they have always been a problematic issue for Turkey, both the anti-terror law, still it is, because it is the main tool for prosecuting or persecuting many people in Turkey nowadays, but also with these special courts, because the concept in itself of special court, it does not comply properly with the international standard about judiciary. What happened with the special courts regarding the high-profile cases that have been mentioned is that after this investigation about the, I call it, businesses of the government in December 2013, it was issued a decision by the government according to which the judicial police should report to the hierarchies and not to the prosecutors. So it was a way to keep control of the police. Then the High Judicial Council intervened in order to defend the autonomy and the independence of prosecutors and judges. And as I said, a law was approved by the parliament according to which the first chamber of the council was basically controlled by the government. At that point, in few days, the first chamber started to transfer judges from some courts to others. The law changed again, I cannot enter in detail, but changed again the anti-terror courts. And thanks to this change, or grounded on this change, the High Judicial Council moved people from the existing courts and in some way interfered in the ongoing trials, in the sense that they changed judges and prosecutors. And also in some prosecution offices, the new chief prosecutors appointed by the first chamber of the High Judicial Council, in this appointment happened in really few days, they started to withdraw the cases from prosecutors. So basically, there was a big interference by the government into the external independence of the council, and at the same time, the council politically control interferes in the internal independence of the judiciary by transferring judges and prosecutors and appointing new judges and prosecutors without their consent. And this is clearly against the international standard about judicial independence. I don't know whether I replied correctly or not.
Yes, okay. We still have some other questions. We'll come later on that. I would like to give the floor now to Yavuz Aydin, who was formerly a judge and now is a dismissed judge, if I may say. So after 2 reports, let's hear the witness of Yavuz.
Thank you very much for giving me the floor. And I must say, this is a great privilege, a great honor to be among such a distinguished panel of speakers from all over the world, all over Europe. And, you know, I must also say that, okay, I'm here as a witness, and I really went through very interesting things. But while there are millions of people and thousands of my other colleagues who suffered much more than me, who are still suffering in prisons, who you know, after the events of deaths in prisons, you know, judges and prosecutors died in prisons in Turkey. And some lawyers died, like Ebru Timtik and some others, on hunger strikes. And many children drowned in the cold and dark waters of Aegean Sea or Evros River, Meriç River. And thousands, hundreds of thousands are still living under this open prison of Turkey, who are lucky not to be locked up in a jail for 5 years now. So while there are such stories, such sad stories, I would be ashamed to talk about my experience in detail. But what I can say is that after 2 months of waiting for things to turn to the correct course, I saw that things are getting worse and worse and I decided to leave the country. And since my passport was cancelled, there was an arrest warrant for me for being a terrorist. There was only one way, paying an incredible amount to the smugglers to buy my freedom. So did I. And how did it start? As Luca in his presentation and in the report rightly said, we were already living in a nightmare in Turkey for years. But the worst point of this nightmare was July 15, 2016. That night, I was just working on my files to be completed in other week, and I saw everything, all these images and video shootages on TV. And, you know, the whole night I watched what was happening. And it was around 6 a.m. when I was so tired, and with partial relief, seeing that things are under control, the coup attempt didn't succeed, I went to bed. And after 4 hours, almost 4 hours, around 10 a.m., I woke up with my phone ringing, and then I learned that I'm a terrorist then. So during my sleep, everything changed. The world changed for me and for thousands of others and hundreds of thousands of others in Turkey. So that's why on different occasions, you know, with reference to the dystopia of Kafka, I said, you know, I went to bed a judge and woke up a terrorist. You know, this sentence really summarizes my life and, along with me, lives of thousands of judges and prosecutors and many others. So after this point, as I said, for 2 months, I waited for things to turn around, but I saw everything is getting worse and worse with this derogation from international human rights conventions, and with suspension of human rights, and with the declaration of state of emergency. This arbitrariness was the new normal. And for that reason, I had to buy my freedom by paying the smugglers, human smugglers. And after a very tiring and very dangerous journey of 32 days, I, together with my 8-year-old son and 14-year-old daughter and my wife, were caught by, you know, armed border guards, police officers of Romania at the border point to Hungary. And that was another point where our asylum process started. And after almost 1 year, we got our asylum in Romania. Afterwards, I came back to Brussels, which I can say has been a second home to us. And now, having this luxury of freedom to speak up, I see this position as a responsibility to those who cannot do this, those who are in prisons, those who are under intimidation, those who already passed away in prisons or on hunger strikes, as I say. So I don't know if it will be possible to share some slides with you now. If you know, from Secretariat, friends can just share the slides. I sent them. I can visualize them. If not, it's not a big deal. I can go on. Can we share it? No.
Sorry, Mr. Yavuz, we cannot share at the moment.
Okay.
There's a. I
No
will
problem.
try. So if you
No, that doesn't work, Yavuz.
Okay, no problem. So as Luca already mentioned in the report, really people already died. And the last incident I saw last week was a 9-year-old girl an innocent girl called Nur Efşan, who drowned in the waters of Evros while trying to flee Turkey. So we have a responsibility to these people. For that reason, I am really here, and I volunteered to be a witness to these arbitrariness and this cruelty. And this is our responsibility as jurists, as lawyers, as judges, primarily, I believe. Because as, you know, I will quote Elie Wiesel in this, you know, he summarizes this very nicely. You know, he says, I swore never to be silent whenever and wherever human rights and human beings endure sufferings and humiliation. We must always take sides. Neutrality helps the oppressor, never the victim. Silence encourages the tormentor, never the tormented. And he also says, there may be times when we are powerless to prevent injustice, but there must never be times we remain silent and fail to protest. So with this perspective, I'm speaking here. So what I can say about what happened after this 15, yes, here are the slides I think the audience can see. And, you know, here you can see judges being arrested by police at the High Court in the first picture, and the other one on the right-hand side of the screen is Murat Aslan. And here you can see the other slide. You can see Teoman Gökçe, who died in prison, and Mustafa Erdoğan, who spent a long time in prison and died in the ward, the prison ward of the prison, the hospital, in such a situation. And Mehmet Tosun, Seyfettin Yiğit, these are the ones, only the judges and prosecutors who died in prison. And there are still, after 5 years, almost 5 years, there are still more than 500 judges and prosecutors in prison for being a terrorist, so-called terrorist. And in the next slide, you can see a young couple of judges who buried their children, their 3 children, on the Greek island of Chios, because since their passports were also confiscated, they were declared terrorists overnight, and they had no other option than fleeing Turkey illegally with the help of smugglers. Their children drowned in the Aegean Sea, and you know, they buried their 3 children here on that island. And please, I'm asking our audience who are fathers or mothers, under which circumstances does a mother or does a father put their children under such a risk? Under which circumstances does a mother or father put their children on a rubber boat at night in open seas? So these are the real stories to be witnessed. And in the next slides, if possible, yes, Ebru Timtik, definitely a symbol to be remembered for years and years to come. And you know, she knew that human body cannot survive that long. After 238 days, she died on hunger strike. So she sacrificed herself in a manner, and this must have a meaning. We should see she did this to draw attention, to stimulate the conscience of humanity. And for this reason, to honor them, I wanted to share their stories instead of mine in detail. I think this is the last slide. So thank you for sharing the slides. And of course, there are these other names like Can Dündar, Ahmet Şık, Ahmet Altan, Enis Berberoğlu, Figen Yüksekdağ, Selahattin Demirtaş, from different segments of society, from among journalists, from among politicians, intellectuals. these people really suffered. Why? Because there was no longer rule of law, there was no longer a judiciary to guarantee their rights. For this reason, the attack to judges and prosecutors at the first place is very important. The Erdogan government knew it, and that's why they called this coup attempt, this botched coup attempt, a gift from God at 3 a.m. in the morning before this attempt was suppressed. Erdogan said this was a gift from God because he knew that he had to get rid of the obstacles before him, obstacles before arbitrariness, obstacles before these illegalities. And that's why the judges and prosecutors and the lawyers were attacked even before the soldiers or police officers. So, and all these things became the new normal of Turkey. So this is not a new story, actually. It was, tried to be realized in different parts of the world, in different parts, different times, but it never reached such a scale it reached in Turkey, in any part of the world. We didn't see such a thing. And this is the result. And just 1 minute before to the question posed to Luca about the role of the dismissed judges and prosecutors in the high-profile cases of Ergenekon, Balyoz, and other things, I want to say something about this. For the dismissal of these 4,500 judges and prosecutors, there is the same copy-paste dismissal decision of the High Council of Judges and Prosecutors. It's not high anymore. It's now Council of Judges and Prosecutors formally. But this is a 60-page decision. And in the 60-page decision, it's all the same. It tells some stories about Fethullah Gülen and some judges and prosecutors who were involved in this Ergenekon, Balyoz, and other cases, and KCK, KCK, Kurdish cases. And only one sentence about me and all others. There's no doubt that he is or she is involved in these activities. And there is no connection, no individualization of the acts. And to be precise, the total number of judges and prosecutors who were involved in all these high-profile cases of 2009, 2010 doesn't exceed 54. In total, the number of those judges and prosecutors are 54. And of course, some people were really persecuted in different ways. But we should remember that Erdogan said during those years that he was the prosecutor of the cases. And we shouldn't forget this. And for the things done by, at the most, 50 judges and prosecutors, more than 4,500 judges have been dismissed and jailed. The same for the indictments.
I think that's clear. Thank you, Yavuz.
Thank you.
There are some questions, but also I want to read something here. Someone is reacting and say, I was in the next door cells with wonderful Turkish female judges in prison. They never deserved what they lived, and they are still living. The most dedicated, hardworking, and just great judges, great women. I salute all of them and wish to see them freed soon and reinstated their status. I think I had to bring this message. But it's now time to go to, we have here in our presence two presidents of associations of judges of Europe. The first one is Filipe Marques. He's president of MEDEL, in French, the Magistrats, Européens, des droits et de la démocratie et la liberté. So in English, the European Judges for Democracy and the Liberties, or the fundamental rights. And I give the floor to Filipe, who of course will bring it in a more general European context. Your floor, Filipe.
Thank you very much, Professor Vande Lanotte. Well, first of all, I would like to thank the International Observatory of Human Rights. I would like to thank you, Professor Vande Lanotte, for organizing this event. Obviously, Luca Perilli for the very detailed and thorough report that we are analyzing today, and also extend my appreciation to all the other speakers, to Mr. Diego García-Sayán. It's an honor to be in the same panel as you, and thank you for the work you've been doing. We've been following it closely in MEDEL, as obviously. To Yavuz Aydin for his example. You say that you shouldn't talk about yourself, but I think your role in speaking out and being an active voice in the promotion of a free Turkish judiciary is really important. So I thank you for that. And I'm leaving for last my good friend José Igreja, because friendship has these things, and that's why I salute you in the last place. We've been friends for many years. So, well, MEDEL has been following the situation in Turkey long before the 2016 coup d'etat. Yarsav is a long-standing member of MEDEL. And I say is a long-standing member because we do not recognize what we consider an illegitimate decision of disbandment of Yarsav. So right after the coup d'etat, we adopted a formal decision in MEDEL not to recognize the dismantlement and to still recognize the former members of the board of Yarsav as active judges and members. So we still consider Yarsav a member of MEDEL. We've been following the situation, as I was telling before, much before the 2016 coup d'etat. And I would first like to start by pointing out, as Luca Perilli already said, in 2012, two members of MEDEL have made an audit to the Turkish judiciary. It was Vito Monetti, an Italian magistrate, and Christoph Schrecker, a German judge. And they went to Turkey on invitation of Yarsav, and they spoke to a lot of people from the authorities and from judges' associations and prosecutors. You can find it. You can find the report of that audit in our website in medelnet.eu, but I think we have the link. If possible, we can share it, at least with the ones who are listening in Zoom. And already in that report, MEDEL found that there were a lot of flaws in the Turkish judiciary. If it is true, and we fully subscribe the report in the part that says that after 2013, the situation became coming down quickly, and after the 2016 coup d'etat, it was a backslide of enormous proportions. In that report, MEDEL already found some worrying signs, some threats. You can see the report, some threats to individual and institutional independence of judges. There were many doubts on the principle of rotation that said that all judges had to rotate throughout the country. And it was seen as a threat because everybody had the feeling that rotation of magistrates was often applied arbitrarily, and it was felt like a pressure because transfers could be abused as a punishment and manipulation of pending cases. There was no legal remedy against decisions of the High Council of Judges and Prosecutors, and everybody complained that the High Council's decisions were not foreseeable, and there was no transparency in those decisions, even before 2013. The fact that the High Council was presided by the Minister of Justice and his undersecretary gave the public perception that it was mainly a branch of the executive power. So even if it was formally independent, there was a public perception that that independence was lacking. They give an example in that report in June 16, 2012. The High Council closed 146 courthouses that were located in small towns and transferred the judges of those courts to other courts in bigger towns. 1 week later, the decision was modified and 46 of the closed courthouses were reinstalled by order of the Prime Minister and demand of the Minister of Justice, who was the President of the Council. And the conclusion of our experts in this report was obviously that when a government or a council has the power to establish or to close courts and to remove or transfer judges without absolutely binding legal criteria, it's an usurpation of an original right of the Parliament and the negation of everyone's rights to a tribunal established by law. They also noted interference of political power in judicial proceedings. So many examples were given that when inquiries of prosecutors or trials in court were becoming dangerous for some spheres of the political power, the reaction was the removal of the prosecutor or the judge from the case, from the office, or from the city. There were disciplinary or criminal measures against judges or prosecutors. Law was amended. They give examples of the Lighthouse case, Denis Feneri, I'm sorry for my pronunciation, the match fixing cases, the MIT KCK case. So they noted there were excessive reactions as a threat to judicial independence and the rule of law. Also, another point that in the Luca Perilli's report is very well noticed is the obstruction of defense. Already in 2012, our experts noted that, for instance, the members of the Diyarbakir Bar Association were under investigation because of statements they had made in court trials as defense lawyers. And obviously some difficulties that Yarsav and Yargisan were already facing even in 2012. And our experts concluded that the harassment of judges and prosecutors associations were obviously an attack on the independence of the judiciary. And then came 2013 and came what Luca Perilli rightfully concludes as the backslide of everything that we could consider as an internationally accepted standard for the independence of the judiciary. What we have seen, the two American authors, Levitsky and Ziblatt, in their book, How Democracies Die, they say that a fundamental, one of the fundamental principles for any democratic society is the existence of two characteristics, which is mutual tolerance, which is considering your opponents as legitimate and with equal legitimacy to yourself, and institutional format must act with could be legal according to the powers that you are given by the Constitution. You should exercise those powers with some self-restraint in order not to interfere with the competences of the other parts of the state. And what we have witnessed even before the 2016 coup d'etat was that in Turkey, that was precisely what was lacking. Even if formally there had been some improvements in the independence of the judiciary, there was absolutely no self-restraint when the executive felt that the judiciary was in any way investigating or becoming or putting it in an uncomfortable situation. And that all exploded in the 2016 coup d'etat. It's, it's needless to say that, like Yavuz, we've listened in firsthand what in 2016 happened. We were faced with a list of prosecutors and judges, which was obviously impossible to be prepared in such few hours. A list that included prosecutors that were even dead or placed in other courts different from those that were in that list months before. So it was obvious, there were obvious signs that that list was prepared long before the attempted coup d'etat. And in the words of the Turkish president, it was a gift from God that gave him the excuse to make a purge in the judiciary, because it's exactly what we're talking about. Faced with this reality, what MEDEL and the other associations, and José will obviously speak about it also, For the first time, we decided together, and the four main associations of judges, and in the case of MEDEL, also prosecutors, we decided to form the platform for an independent judiciary in Turkey. And we have been trying to do everything which is possible for us to do, to give support to our colleagues and their families, and especially to give them hope and visibility, which is something which in the long run is what you need. You need to know that you have the support, and there are people that believe in the rule of law, people that believe in the independence of the judiciary, and that you are not alone in your struggle and in your fight. That's basically what we've been trying to do. What we see in Turkey, and that's one of the things that Luca Perilli rightfully points out in his report, this is not a problem of the judiciary. This is a problem of the whole society. You have attacks on the freedom of media. You have attacks on the freedom of the academia. You had, it was not only a purge in the judiciary. You had a lot of public servants, university professors, all spheres of the society have been affected by this. And if it is true that, like Luca Perilli said, without justice, there is no rule of law, you cannot have rule of law without a free civil society. So it comes in both ways, and it's a problem of the whole Turkish society. And this situation in Turkey, what I would like to focus on is that it's not only a problem of Turkey, and this represents a challenge to all of us. And on this point, I would like to focus on the European Court of Human Rights. This Turkish situation should lead us to rethink many aspects of the international system of protection of human rights. Right after the coup d'etat, MEDEL filed cases for interim measures, or tried to file cases for interim measures, because it was obvious for everyone that there was no internal domestic remedy in Turkey that all the dismissed judges could appeal to. We faced in the European Court of Human Rights many obstacles, many formal obstacles. And I can give you some examples. This was 1 or 2 months right after the coup d'etat. First, there were a lot of documents that were required, and they asked us for, they were constantly asking us for different documents. When we provided them with all the documents, then the problem was the signature, because first it was signed by the vice president of MEDEL, and it had to be the president. And then after the president signed, there was another formal. So we had a lot of formal obstacles in order to present an interim measures request. Then we had to face the problem of the internal domestic remedy. When it was evident for everyone that even before the 2016 coup d'etat, if we had doubts before, after 2016, it was evident there was no domestic remedy. And then we asked for a third-party intervention recently. The last one was with 2 other associations, the European Association of Judges and the Association of Administrative European Judges. But the first one, 1 year ago, MEDEL asked for a third-party intervention, and the European Court of Human Rights took 1 year without even answering us, and they answered only 1 year later, just with a letter saying it was not in the good interest of justice. What I'm saying here is that the European Court of Human Rights, which is, it's not excessive to say, one of the, if not the institution that has most contributed to the implementation of human rights, and in that sense to bringing peace to Europe, maybe it's time for us to rethink how the European Court of Human Rights acts, and especially if the European Court of Human Rights is not acting in denial of justice when it takes more than 14 years to decide cases. We had a decision yesterday, it was Bilgin versus Turkey, which the European Court of Human Rights issued its decision on an application that was presented in December 2006. It was a judge that was complaining that he didn't have an effective remedy or an effective appeal against the decision of the High Council And he presented his application in December 2006, and the decision came out in March 2021. What I'm asking is, often the European Court of Human Rights convicts states for excessively long procedures. Shouldn't we have a court to convict the European Court of Human Rights for excessively long procedures? Maybe we need to rethink the international system of protection of human rights. So the situation in Turkey is also a challenge to all of us, not only to the Turkish people. And just to finish, not to exceed the time that I've been given. Yavuz has told everything when he showed the picture of those parents in front of the graves of their children. But I would like to, what I'd like to stress and to point out is that we may talk about institutional aspects, we may talk about the judiciary as a part of the state, but we're talking about real people. And one of the things in MEDEL we wanted to bring to people is that we are talking about real people, judges, prosecutors, families. And in another link that I hope can be shared with you, but if not, you can go to medelnet.eu and try to find it. We've published, translated into 12 different languages, all the emails that we received immediately after, emails and letters that we received immediately after the coup d'etat, coming from judges who had been arrested, dismissed, from their families, desperate. And if you read those emails translated, as I said, in 12 different languages, you will see that we're talking about real people. You have clear examples of what Luca Perilli says in the report. You have the picture in that ebook of a letter sent, of an email sent by a lawyer to one of the judges that was trying to have him defending him. And the attorney saying, I beg your pardon, I cannot represent you, that's too risky, and my legal help wouldn't change the verdict. This is an answer from a lawyer to a judge that was asking him. And you have letters like this one that I will read a short part for you. I'm a 17-year-old boy from Turkey. When the failed coup happened, I was in Europe with my family having our holiday. My father was a prosecutor and my mother was a judge. We returned to Turkey because we knew we were innocent. But despite the fact that we would have stayed in Europe, my parents were put in jail in order to prevent them running away before the trial. Our bank accounts and private property have been taken away by the government. The lawyers were threatened by the government, so no lawyer accepts the case. Even if they do, we cannot afford it because the government took our money. Like I mentioned before, it has been 4 months since I saw my mother. This is against the law in any circumstance. I'm just a son who wants to see the mother. What kind of danger could I cause? This was one of the letters that we received in MEDEL. You can find them in that ebook. And just to finish, like I said, not to exceed the time that I've been given. I would not like to finish this without talking about Murat Arslan, who's the president of Yarsav. He's the member of the president of our member association. He's been in jail since 2016. And he's a clear example, and he's a model of the kind of judge that we would like to see in Turkey. A brave, courageous judge that stands up for the rule of law and stands up for his people in standing up for the rule of law. And I would just like to finish quoting one of the sentences of his speech when he accepted the prize in the Václav Havel Human Rights Prize that was given to him by the Parliamentary Assembly of the Council of Europe in 2015. And he said, the price that we are paying just raises our faith in the coming days that the rule of law and democracy will be internalized, and just raises our fighting spirit. And that's what the message, the best message that I think can be left here is this sentence of Murat Arslan. Thank you very much.
Thank you very much. We had some questions that you already answered, actually, about the domestic remedies and how the European Court has been acting on that. I think we can say that it had caused a lot of problems. The only positive thing is that very slowly now, it seems that European Court is a bit going away from the earlier theory, but of course it's still a problem. You also answered without having the question about the time, the period it takes, the long period where a lot of people were answering questions, why does it take so long, and is there no urgency? And also a bit referring to the speed that has been given to some Polish, right way, Polish judges' complaints. And while there are now a lot of people, I think it's 200-300 of them at least, who are pending before the European Court. There's a case of prosecutors and judges, and everyone is waiting a lot to see the judgment of the courts on that. Someone was saying, yeah, and how strange it is, the Kavla case has been a lot of publicity, the judge's case not. I think we can answer also the judge's case has not had a verdict yet, so it's a bit different, but indeed we are quite impatiently waiting for the verdict of the European Court on this judges and prosecutors cases. That allows me to go to Mr. José Manuel Igreja Matos with the European Association of Judges, excuse me, but I have to, there is a demand to José to say, could you mention the support of Turkish judges by the European Association of Judges and the possibilities to donate for this cause? I will now do something that is very unprofessional in a digital world, but I cannot put it. But this is the email address where people, if they want to, can contact to support the Turkish judges. So normally I should have been able to put that in a digital way, but I'm an old man, so I have to do it in the old fashion. And anyhow, there's also a webinar Friday at 13:15, Judicial Independence and Separation of Powers in Europe and in Switzerland. And that is still, it's for free. There's no registration fee to pay. It's a registration that you can do. And so Thomas Stadelman, we heard your message and I hope we responded to that. Mr. Igreja Matos, I also would like to do something that in your speech, you give some attention to what has been asked by different people. How can we put the European values, the EU values, how can they say that the European values are so important if we see the way the European Union is acting towards Turkey? And as the president of the European Union of Judges, of Association of Judges, I think it's a question that really fits you well. You have the floor, Mr. Igreja Matos.
Thank you, Professor. It's really a great question. I will try to answer during my speech. First of all, I want to thank you for the invitation. It's a great honor to be here. I've been in several panels, but it's difficult to choose one that is more comfortable to me because I'm here with three friends, with three persons I admire. Diego García-Sayán, my particular friend. We work on several platforms, also in United Nations. My dear Yavuz, I always remember the 1000 Robs March and how important was the presence of a Turkish colleague there in Warsaw, showing solidarity to the Polish judges. And obviously my colleague, my Portuguese colleague and friend, Filipe Cesar Marques, also a great defender of human rights and judicial independence. So, the best speeches are normally the shorter ones. It was in the Hamlet, Shakespeare said that concision is the soul of wisdom. But of course, I will try to be as concise as possible, but here and there, in some moments, I will fail. The horrors experienced by thousands of Turkish judges during the past years oblige us to speak more, to repeat ourselves, especially if you are direct witnesses of the injustice of their situation and of the moral collapse of Turkish political authorities on destroying rule of law and judicial independence in their country. So besides concision, let me mention a word that sounds almost the same, but it's quite different: compassion. Compassion is the basis of morality, explained Schopenhauer many years ago. And precisely when talking about morality, one must remember the distinction pointed out by Martin Luther King. Martin Luther King said that in politics, the question often is, will it work? But when we speak about conscience and morality, we always ask, is it right? Even if politically things have worked in the past years for those who are in power now in Turkey, we all know, and that must be repeated, that it was not right. It was not fair. And again, we should appeal to the compassion much more than the concision. It's better to have compassion even if we lost concision. So my words will be personal words, a personal testimony. It will be also about the work that is provided by the European Association of Judges in the past years. And I will try also to comment briefly on the excellent report of Turkey Tribunal, of the author, Mr. Luca Perilli, is here. I already off record salute him for the excellent report, and I will do it again publicly. It's a very good report with many facts. The assessment is very objective. It's not only opinions, as you can read, it's about facts, and that it's sometimes the most difficult thing to perform. So my personal testimony as president of the European Association of Judges, and before that as member of the association and working in international level since 2010. In this regard, I would like to start to salute warmly my friends, my brothers, my sisters, my colleagues of Turkey. They are now all over the world, not only in Turkey, many of them escaped for other countries. We miss you. We continue to believe that one day we will meet again, celebrating your freedom and the return of Turkey to the path of democracy and rule of law. Allow me to share two brief episodes on the EHA's life to testify the commitment of our friends from Turkey, from YARSAB, that is our member, our national member of Turkey, particularly those who work with us in very different levels in our internal bodies, in our different study commissions that we have in the International Association of Judges, our mother organization. We have 4 study commissions dealing with judicial administration, status of the judiciary, civil law and procedure, criminal law and procedure, and public and social law. The representatives of YARSAB were always on the front line of our technical work. In particular, one of them was vice president of our first study commission. He was elected. And I must say, after all these years, that symbolically, he is still our vice president, since we decided to maintain until he returns as our vice president of the first study commission. And also YARSAB symbolically is one of our 44 European members, is still on our organization chart as member of the European Association of Judges. Their engagement and dedication to a judiciary devoted to judicial independence was a trademark of YARSAB, members within our organization. I still remember, and it was a wonderful event, the General Assembly that EHA have in 2011 in Istanbul. They worked very hard to deliver such an unforgettable event. The second episode passed in the end of 2015. I was in the airport returning from some international meeting, and I was with with a Turkish colleague that was also there. And he told me, José, I've been transferred. I've been transferred to a new court near the Syrian border in the war zone. I know what is happening in Turkey, and I want to salute you. I want to embrace you. And he has tears in his eyes. He was very moved. I didn't know back then, perhaps I was a little naive. Perhaps I was not fully informed. I never saw him since. He was arrested. He's still in prison. And for him, is always my memories, my remembrance. He was a wonderful colleague, very engaged on rule of law, always working hard to bring Turkey to these international standards that we preserve and to the European values that you mentioned as at the beginning. He, like all the others, will be always remembered no matter what. Institutionally, the European Association of Judges, since 2016, the alleged coup d'etat, issued, I went to our website, 95 public statements, endorsement, public interventions. Most of them in recent years, in the past 2 years, were within the platform to help our Turkish colleagues. The platform that Filipe already mentioned, we are very proud to be members of this platform with the other 3 European associations, MEDEL, the European Administrative Association of the European Administrative Judges, and Judges for Judges. The first statement we issued was in 16 July 2016. We received an email from a colleague saying, some say police are coming to detain us, me and my wife. In case I am arrested, I'm writing to inform you. In this very same day, we issued a statement appealing to human rights on Turkey. Of course, we remember in October 2016, the arrest of Murat Aslan, already mentioned, our esteemed colleague. He was arrested in the exactly same day that we held our 2016 October General Assembly. It was in 19th of October. Maybe it was not a coincidence. And in the exact same day, we called for an immediate release of Murat. We remember also the Václav Havel Prize that Murat Aslan has won. I remember the long hours preparing the candidacy, filling all the papers, very bureaucratic procedure, all the colleagues that help us on that, the long list of colleagues, and in the end, the decision that was that we were so proud to hear, and it was so well deserved for Murat Aslan. Murat said in his speech, "I'm speaking to you from a jail in a country where the rule of law is suspended, moves far away from democratic values. Dissidents are silenced, human rights defenders, journalists, people asking for peace, people who shout out that children should not die, labeled as terrorists and jailed." Murat Aslan, our dear colleague, for most of us, a true representative of judicial independence and rule of law, as Filipe already pointed out, is still in prison. Another initiative that I would like to underline is the Provident Fund of the IOHR on Turkey, already mentioned here. Our moderator, Professor, thank you for showing the email address. I can ask our secretariat to provide further details. We have spent now more than 200,000 euros to this cause. We only give 900 euros or 500 euros. It's a symbolic, mostly symbolic donation, but we have helped so many hundreds of families that we think this is one of the more pragmatic and concrete assistance that we have done to the Turkish cause. The most rewarding is the letters, hundreds of letters that we receive acknowledging this support, and especially speaking about the moral support that represents for them to know that they are not alone. We try to show this compassion, but for sure, and this is the real thing that I want to share, is that Turkish colleagues, judges and prosecutors and their families have shown their compassion to us when writing all these letters. In this very sad and gloomy reality, there are at least 2 positive outcomes I would like to underline. First, the platform, that was a very, very moving and very interesting initiative that I already spoke about it. And the second, I think we can say, the European Association of Judges and all the others, that we have managed to show that the Turkish colleagues are not alone, that we are doing our best not to let the normalization of normal in Turkey. Geopolitics, realpolitik, as they say, cannot be a reason to ignore the eradication of judicial independence in Turkey or anywhere in the world. Again, This is about the distinction about what it works and about what is right and what is fair. To briefly comment on the report, the report speaks for itself. It's an excellent report. Since the introduction of the start of the state of emergency, over 150,000 people have been taken into custody. Over 78,000 people have been arrested based on these terror-related charges. But as the report underlines, the scale of the operations was particularly shocking with reference to the judiciary. And this causes a new problem for all of us. That is, we have now in Turkey what I will call a new fake judiciary. At least 45% of the Turkey's new judges have less than 3 years of experience. And our platform for an independent Turkish judiciary already observed that reliable reports say that 800 of each 900 appointed, newly appointed judges have direct links to the ruling political party in power. So this means that we are facing for the future the problem of these fake tribunals, fake courts, and fake judges. And this is another reason of concern, not only in Turkey, but also in other countries. Let me now go to some short conclusions. First, on the negative side, as already was expressed by the questions that you mentioned and by other speakers, it is clear that, and directing the situation for the European Court of Human Rights, it is clear for us that there is a lack of independent, impartial judiciary in Turkey, that vanishes the effectiveness of a remedy, the judicial remedy, the famous judicial remedy demanded by the court. It is clear the incapacity of Turkey to ensure this effective domestic legal remedy in the sense of the European Court of Human Rights. I think the only goal now for them is to procrastinate the ICHR rulings. More than that, we have witnessed that the European Court of Human Rights decisions are now ineffective. And you can see, for instance, Latin Demirtas and Osman Kavala cases. Yet another development that is that's not been mentioned very much is that we have this new amendment on the Turkish constitution. And now with the constitutional framework, after this last amendment, we have a clear subordination of the judiciary that is totally dependent of the president, whatever he or she is, giving now a constitutional backing to a dependent judiciary that must be obedient and heavily controlled. Well, I would like to end with a more positive note, also about the European Court of Human Rights, although sharing absolutely Filipe's concerns. Because we all need hope when talking about Turkey. After a very long period, the court finally formed 4 groups of cases: Altun versus Turkey and 545 others, Murat Ulusov with 168, Samil Sevinç with 258 cases, and finally Ibrahim Ataman with 53 other cases. The answer from the court to our request, being a third-party intervention, for a third-party intervention, was seen by the platform in a positive approach as a clear sign, and I'm quoting, that the court is already sufficiently informed about the situation of the judiciary in Turkey and its dependency on the government, a situation so visible that is been strongly highlighted by several international organizations. And we had it. We are now optimistic there will be no further delays in the proceedings, and that in a very short time, the European Court of Human Rights will adopt groundbreaking verdicts upholding the independence of the judiciary in Turkey. That will be an important first step to reverse the situation that is still very tragical. Yesterday, decisions on Ömer İmine-Gagulu versus Turkey, saying that was a violation of Article 6, fair trial, and Article 10 about freedom of expression for judges. You know, Omer was was one of the members of the association, Yarsab. He was the spokesperson, and the court said that Yarsab defended the principle of rule of law. Also, the case already mentioned of Bilgan versus Turkey about the undue transfer of judges, a very good example that I experienced with this colleague that I met in the airport, and I want to dedicate to him my simple words. All this reinforces this aspiration for a greater confidence and hope for the future. Allow me to return to Dr. King, to the Martin Luther King eulogy on morality, and I will finish with an appeal to the international community. Let's do what is right, knowing that not only for judges, but for this immense community of goodwill, men and women working for human rights and rule of law, one unique conclusion must be extracted. At the end of the day, the only answer, the only solution to the Turkish judiciary that can possibly work must be fair and must be right. Thank you.
Thank you very much. I think that was a very clear statement. I would like to add 2-3 things. We had a remark from someone who said, listen, while thousands of judges, prosecutors, and other victims desperately waiting some voice from the EU institutions, why the EU institutions are so quiet, why there is not enough voice or reaction, what should we do? It is no rule of law, but a rule of law in the EU and the European Convention. And that's a very important, shall I lose my hope from the European Union? I think that is a clear message that all of us, we think indeed that the European Union could be much more proactive in this. If we see, lucky enough, how strongly they react on the Polish judges and try to do something at least, we cannot otherwise see that for the Turkish judiciary, we do not see the same reactions for the moment from the European Union, and we should. There is also for Diego a suggestion that is that if your office could come as amicus curiae into the third party for the European Court, that's a suggestion, but I hear from José that for the moment they're expecting now fast the verdict, so perhaps it is not the right moment, but it was a suggestion of one of the people who are following our webinar that your office could intervene. And I would finalize this webinar with, let's say, a testimony. I think that we should give to all the audience. By the way, for the people who are on Zoom, we had a problem with Zoom. The numbers were restricted. We forgot by a human mistake, but that can happen, to open the Zoom for more than hundreds, but at the moment, more than 1,700 people have been viewing on YouTube. So we have not a lot of people in Zoom, but we have a really big number of people who are on YouTube channel following our webinar. And that is the last testimony. Thank you to all valuable panelists. So to all you, I can only join that. Mr. Judge Yavuz Aydin very touchingly talked about Nuref-san, 9-year-old girl and other victims who left this life on the way to access to justice or freedom. I want to highlight some fact which I learned during this panel. The rule of law makes it possible to breathe for the citizens in a state. Nuref-san and lots of other children were trying to find a place at which it was possible to breathe. Her sad voyage to freedom shows the situation of access to justice under Erdogan's regime. Best regards. I think it is a very touching and clear voice that we hear, that indeed, as he said, this person says, the rule of law makes it possible to breathe for the citizens in the state. I think it's a good resume. I thank you all. I thank all the people who are assisting to the webinar. And just to say that from 7 till 11 June, we will hold our Turkish tribunal in Geneva. All the reports are done now. The judges are appointed. So from 7 till 11, we will be having this tribunal. And I already can say now, this is not the last thing we will do. After the tribunal, we will come with new initiatives, because at the end, we have to take care that everyone in his own country can breathe and can breathe the freedom he deserves. Thank you very much. Have a nice day. For the rest, everyone, thank you. Bye-bye.